these proceedings at least by midday. We had allocated the petitioners, the main petitioners, 1 hour to do the rejoinder, and then the other petitioners were allocated 15 minutes. So this is the time now for the main petitioners, the team led by Senior Counsel Honorable Orengo.
My Lady, the Chief Justice, before the main petitioners commence their response,
Yes.
there were issues raised by the bench yesterday on which we are requested to provide answers today. At what stage will we be able to do that?
I think it is now.
It is
we
now.
must have forgotten you.
Thank you, Madam. Just give me 1 minute, I'll get my notes.
Can we give you 5 minutes to do that? I remember it was like 1 or 2 questions which were directed to you.
Madam, the dilemma I have
Eh.
is that there were about 3 questions raised,
Yes.
which I should respond to. But if you may recall, you had also permitted the advocates for His Excellency the Vice President to respond to the application by the Chief of Civil Service, Mr.
Yes,
Kenywa.
that is correct.
And they did that, and we didn't have an opportunity to comment on their response at all. So I will try to be very, very, as usual, very quick and respond in summary, but I will need about 10 minutes.
Okay.
And my learned friend, Mr. Gatia, Senior Counsel, also tells me he has a request to make. Thank you.
Madam Chief Justice, you recall yesterday how gracious I was. I donated 32 minutes to court.
Are you claiming it back?
No. No, I will not do that because the court has work to do. All that I request is 5 minutes, nothing more than 5 minutes of your time. We are doing quite well this morning. Thank you so much. I don't know who will go first, whether it's my senior or ourselves.
I think you can go first.
Okay.
Chief Justice and Deputy Chief Justice, members of the Supreme Court, just to point out that there were specific questions that were addressed. For example, to counsel acting for the 4 commissioners. And we would like to know at what point we are expected to respond to those questions. After the petitioners. Thank you.
Good morning, Madam Chief Justice and members of the court. I seek a little clarification because similarly we had several questions directed to us which we thought we would react to before we make our rejoinder. And I thought yesterday you had clearly stated that we'd have 30 minutes. We had about 27 questions. Are we at liberty to proceed to answer those questions right away?
Sorry, Senior Counsel Orengo, you have 1 hour to respond, but I hear you saying you need more than 1 hour because of answering the questions. And therefore you're asking for another 30 minutes.
With a little bonus.
We can see what we can do with 1 hour. If you extend maybe 15 minutes.
It would not be enough There's a very important question which just...
It's all right, because even the time we are wasting now, you could be answering.
Yeah, so
Yes.
in the 30
We're just
minutes...
asking you to be kind, because we really have to get to the real business
Yes.
of writing the judgment.
Thank you.
And we
In
don't
the
have much time.
In the 30 minutes that we'll be answering those questions,
Yes.
my lady and my lords, you'll be addressed by my honorable friend, Mr. Otiende Amolo, particularly on the question of turnout, which was asked by Justice Wanjala, and Firoz Norji, Senior Counsel, Paul Mwangi, and Ms. Julie Soweto will address you in those 30 minutes. And I invite Senior Counsel Otiende Amolo to address you on the first question.
Yes.
Not yet.
Not yet. Not yet. Yes. Senior Counsel Oraro, please, or is it Gatia?
My senior is beckoning my team. You allow us.
Yes. 5 minutes.
Chief Justice, Deputy Chief Justice, distinguished judges of the Supreme Court. Actually 3 questions were asked that are relevant to submissions yesterday, paraphrased as follows. 1, if the National Security Advisory Council 4 knew the results before they went there, and 2, why would the result not be announced the next day to build consensus? And 4, what would be the effect of the non-involvement of the 4 commissioners in the verification and tallying vis-a-vis Article 138(3)(c? Our response is as follows. 1, it is our submission that all factors point to an inescapable conclusion that the 4 members of the National Security Advisory Council, by the time they went to the Bomas of Kenya National Tallying Center, and by the time the head of public service placed a call on the returning officer of the presidential election, by that time they knew. And this is our evidence. By the morning of the 15th, letters had been issued by the returning officer of the presidential election, Mr. Chebukati, to all the presidential candidates and members of their family to be at the National Tallying Center for the declaration of results at 3 p.m. on that day. And my client already had received that invitation. I believe the other presidential candidates had those letters. And therefore, they knew by the time these 4 these state officers went to the National Tallying Center, they knew that the verification tallying had been completed, and what was pending was the declaration of the final result. It is our submission, Chief Justice, distinguished judges of the Supreme Court, that these 4 went to the National Tallying Center not for any other reason but to try to interfere with the declaration of results and thereby try to alter the sovereign will of the people of Kenya, which had already been verified and tallied in accordance with Article 138(3)(c). 2, it is our response that the results could not be announced the following day because, according to the affidavit of the chairperson of the commission, and I'm using the word chairperson on advice by Justice Ndungu, which I agree with entirely, that by that time, it was not possible for any form of consensus, because then the follow-up question was, I think from Justice Lenaola, why, for example, the returning officer would not have waited for an extra day, which he had, to build consensus on the 4 walk-away commissioners. It was not possible. It was very clear that the intention was to try and veto the will of the people, and therefore the chairman had to declare those results. Number 3, the 4 who left also, their colleagues had been injured. And so the chairman had, in our view, make the announcement that day because of the gravity of the situation. Finally, the question that this court ought to ask itself is whether the working away of 4 commissioners at the tail end of a process which they have admitted was complete, except the declaration, can veto the sovereign will of the people of Kenya. Can the walking away of commissioners at the tail end of a process they have been involved in be the basis of vetoing the right to franchise in Article 38 of the Constitution, which is the expression of the voter? Thank you, and we prayerfully submit.
Chief Justice, my lords, Deputy Chief Justice, Lady Chief Justice, I'll begin with the question which was asked by Justice Lenaola, and that is, what orders are we seeking? The orders we are seeking is for this honorable court to dismiss the allegation by the second respondent on oath, which have not been accompanied with sufficient level of evidence to justify proof beyond reasonable doubt as required by the Constitution and as determined by this court in advance. And that evidence is beyond the political statements which have been made by my learned friend, Professor Kindiki, just a few minutes ago, and which have never been put on record. On the issue of Rule 87.3, unless my view and my humble submission is that rule, contrary to the provisions of Section 39 of the Elections Act and Article 183, 3C, is the only regulatory framework which confers those powers which have been reserved for the Commission and grants them to the chairman. It is contrary to the Act, it is unconstitutional, contrary to the Constitution, and that was so observed in the case of Maina. Now, there was a question raised by Justice Dr. Wanjala, and you queried whether NSC would have gone to influence the alterations of results without knowing the results. My learned friend, who has just appeared, exhorts that the results were known because invitations had been sent out and the letter had been sent out. To the contrary, the evidence before you by the chairman was that he had gone to tally, to obtain the final tally only after he had met the commission, and that is found at paragraph 676 of his affidavit, where he says that after the NSAC team had left, the Commission Secretary, Chief Executive Officer, who was also the alternate team leader of the tallying center, Marjan Hussein, walked into the boardroom. Yeah. The purpose of the meeting was to receive the final tally of the results of the presidential elections before he could proceed to declare. And it is only thereafter that the results were handed to the commissioners and they walked out. So that even by the admission of the chairman, he was not aware of the results until after the NSAC team had left. Now, the Deputy Chief Justice asked about the effect of NSAC on the independence of IEBC. Your Ladyship, NSAC is a body comprised of all the heads of the security organs in this country, the head of civil service, the representative of Attorney General, and other heads in the government. Its purpose is to receive all the information on national security and give advice, not act, but give advice, so that even if they are of the view that it is insecure to be in this court at this time, it is the NSC who will give advice to the judiciary, and that is not an interference with the independence. And we have to take their role in the context that these 4 members of the NSAC were co-opted by the bigger body. They were not there on their own account, which has led to them now being vilified for undertaking an official duty they were requested to undertake. I had shouts from another friend on behalf of His Excellency, the Deputy President, of crucify them. In fact, this has indeed led to tweets today, and there are many, to various members of the NSAC telling them we shall revisit. This is what this type of allegation brings, and that is why I humbly request this court to look at the nature of the allegation, the burden on the people who are making the allegation, and dismiss them if there is no proof, and in my humble submission, there is no proof, so that we discourage this political vilification on officers conducting their official duties. Let's be careful, and I humbly request particularly my learned colleagues on what we wish for this country. Let us not wish mob justice to be the arena of operations whenever various functionaries are discharging their duties. Let politicians do politics, but let them leave professionalism to those who are engaged in various areas. In fact, since this process started, there has been a lot of vilification on the judges, on the parties appearing. In fact, tweeting has been the norm on discussing this issue instead of looking at it soberly. We can't stop tweeting, they are entitled to, but we can't bring it to this court. That's my humble submission. I beg that these allegations be dismissed with the contempt they deserve.